All right, like I said, my name is Chris Ralph. I'm with Health Law Services. This presentation is quite lengthy. We're going to speed through some of this, so we're going to skip over it. We're going to try to get to the pertinent details here. Put this little image up here. There was a news story that I was interviewed in down in South Florida a couple of weeks ago that really caught some attorneys off guard, saying, how is this even possible, and are you getting people in trouble? So we decided to put this together so people could really see what is required and how somebody can go about meeting these elements, okay? I guess they already spoke about us here. We don't have to go through this. Let's see. Okay, so the things that we're going to get into here is the history of past and present Florida laws, the current client experiences that people are going through today, how to proactively establish a medical necessity defense, as well as the requirements for caregivers currently in Florida, which seems to be a pretty taboo subject at the moment until November. So, and get into this. These are the laws that need to be outlined for somebody to take their affirmative defense and make this an absolute defense from any criminal prosecution. And I have not had the opportunity yet today to meet Mr. Bob and Kathy Jordan, but I can say that you are an inspiration to everything that our firm has done. So from the bottom of our hearts, thank you very much. There's one little thing that I want to show here. For anybody who's not familiar, the House of Representatives recently passed Amendment 25 to the Appropriations Bill 4660. Now, in this bill, they outlined the states that currently have existing medical marijuana laws. Now, they did not outline the states that have ballot initiatives currently pending. If they did, New York, Kansas, and numerous other states would be on here. But as you see, Florida is listed as one of the 23 states that currently allow medical marijuana. And that is because of this case right here, L.V. Musica versus Florida. L.V. Musica was an individual who was suffering from glaucoma. She eventually became a federal medical marijuana patient. However, in 1989, she was found not guilty by a circuit court judge, and he reasoned that ignoring the plight of people who use this as a medicine renders any law callous to the most basic of all human rights, the right to self-preservation. Okay? This is the first law that was put on the books as far as case law. The reason why case law applies here is this. The state of Florida is a common law jurisdiction based on Statute 2.01. This means that any English law enacted prior to 1776 have been adopted by the Florida legislature based on this Statute 2.01. Now, English law allows for an individual to use any substance that is found to be medically necessary without penalty. Now, when these laws were created, we didn't have prohibitions on cannabis. So to avoid arrest when confronted with law enforcement, and this is what we've been working on for the past year with all of the elected sheriffs and state attorneys, when you are confronted by law enforcement, that's all you have to do is prove that you are in compliance with these next laws that are following, okay? First of all, we have a case of Barraza versus Florida. This case was a Supreme Court case in 1978. It was not a medical case, however. This was a criminal case. Linda Barraza was charged with shoplifting. When they went through her purse, they found she had less than 5 grams of cannabis. Subsequently, she was sentenced to, I believe it was 25, 30 years in prison for under 5 grams. Now, Ms. Barraza did not appeal the conviction because she was guilty. She appealed the ruling stating that cannabis does not cause harm. Now, the court overturned her conviction, or overturned her sentence, should I say, and they held that the danger to the public presented by marijuana and its use is so different and less severe than that presented by opiates, it cannot constitutionally be treated as if it presented the same dangers. Mind you, this was a criminal case, not a medical necessity case. Now, when we fast forward, of course, we have the L.V. Musica case here, which we just talked about. Then we have the case of Jenks versus Florida. Kenneth Jenks was convicted of cultivation of cannabis. He was suffering, him and his wife, should I say, were suffering from HIV. Now, in 1991, the First District Court of Appeals, which is the highest court in the state to hear a medical case, the Supreme Court has never heard one here, ordered the trial judge to enter a judgment of acquittal, and they outlined the elements that one needs to meet to ensure that they are afforded an absolute defense from any criminal prosecution. And that is, somebody must not have a control over the circumstance which required the choice between the lesser of two evils. I don't think anybody here or anybody's family member intentionally caused cancer or ALS or any of those conditions. Second element is that no less harmful alternative must be available. Well, the Florida Department of Law Enforcement has done us a favor, and they publish a drug death report based on prescription drugs every year. In it, they include cannabinoids. Cannabinoids, according to the FDLE and every other organization around the world, except for some naysayers of the medical marijuana movement, agree it has never caused a death. And contrary to that, alprazolam, Xanax, has caused 639 deaths in the last reporting year of 2012 in the state of Florida. You tell me which is less harmful. Then, the third element is that the harm that someone is seeking to avoid must be less offensive than the criminal act committed to avoid it. In other words, if you're simply in your home and you are using cannabis for yourself medically, you have an absolute defense from a prosecution. Now, if you're driving down the road and you got smoke blowing out the windows there, that's not going to apply because you are putting other people in danger at the same time. So then they're going to convict you. But this is a requirement. Contrary to popular belief, if you have your documentation in order prior to being confronted by a law enforcement officer, you are not subject to arrest. You may be subject to investigation, as Mr. and Mrs. Jordan can assert, but you are not necessarily subject to arrest because an officer has to decide right on the spot whether or not he believes a law is being violated. If you have documentation showing the law is not being violated, and they arrest you, they are acting in bad faith, and according to the Supreme Court of Florida, they are exhibiting wanton and willful disregard of human rights because the courts have already stated that it is a violation of your right to self-preservation to deny somebody any medicine that's necessary for them, okay? Fast forwarding a little bit here, the Sowell case is pretty interesting as well. In the 1978 ruling, it required the state of Florida to reclassify cannabis because it cannot be treated the same as opiates. So what the state of Florida did is they reclassified cannabis from a Schedule 1D to a 1C, simply allowing judges the discretion to sentence people based on their own guidelines. Well, the state of Florida tried prosecuting somebody because they stated that because it was reclassified and it is now treated as less harmful, the medical necessity defense does not apply. The court overturned the conviction because the defense still applied. The reason why is the defense did not apply based on the ruling of Jenks. The defense applied because we are a common law state, and because of Statute 2.01, it has never been abrogated from our laws. It is a law that predates the Constitution of the United States of America, okay? Now, one question we get consistently is, well, if this requires a doctor to do this, I can't see a doctor in Florida. We could not disagree more. In 2002, the 9th District Court of Appeals of the United States Federal Court enjoined the DEA from either revoking a physician's license to prescribe controlled substances or simply conducting an investigation of a physician that might lead to the revocation where the basis for the action is solely on the physician's professional recommendation of the use of marijuana. We do have physicians that have been concerned that this can violate the Florida licenses. No Florida license allows you to prescribe a scheduled substance that is federally controlled. It is a federal license. That's why a physician has to have both a federal and a state license. A physician, by simply recommending or providing a statement of necessity, is engaging in their First Amendment right to free speech. Any physician in the state of Florida or in any of the 50 United States of the U.S. have the right to recommend cannabis. Okay? You simply cannot aid and abet somebody in obtaining the medicine. That is the difference. If a doctor, for example, says, go to this treatment center and get this medicine, well, now they're in violation of the law. They're aiding and abetting. If they simply write a statement, the physician can know where they're going. The physician just can't tell them where to go. That's the difference. And that is because a California physician, the DEA attempted to prosecute, and it was overruled. Okay? Now, plenty of people ask us if treatment centers or dispensaries are currently allowed. Well, Zy Baranoff ran one in 1997 in Key West, and up until recently, it was still in operation. Now, he's closed. I believe there were some federal issues that have gone on here. But according to Norm Kent, he states that we have set something of a precedent, because any individual that is suffering from a condition that they did not bring about has a right to use this medicine. If you look at, I'm going to cite Mr. and Mrs. Jordan again. If you look at the memorandum that has been circulated regarding Mr. and Mrs. Jordan, they state that the person that they were investigating was Robert Jordan, not Kathy. Brian Iden, the division chief of the 12th Circuit, issued a memorandum to Manatee County stating that Robert Jordan has an absolute defense from any criminal prosecution for cultivating cannabis for his wife because he is acting as their caregiver. No different than what this says here based on a medical necessity distribution defense. So if you are somebody who is suffering from a condition that needs the least harmful medication available and cannabis will work for you, you do not have to wait for the Amendment 2 to pass. We want Amendment 2 to pass, of course. We want regulations, we want proper controls. But we are not going to stand for people dying currently simply because we have not voted yet. And that's where we're taking a stand, and we're saying no. Okay? We did have a couple issues regarding the Department of Children and Families. Since then, we have taken care of this. There was a lady here that spoke earlier, Mrs. Petro. She was threatened by the Department of Children and Families to have her child removed because she was giving her child low THC cannabis oil, hemp oil. Well, we went ahead and got in contact with the Department of Children and Families, negotiated with them, with numerous individuals there. Finally, we got to Chastity O'Keefe, I believe her name is, who is General Counsel for DCF. I believe that's her name. Osteen or O'Keefe. Please don't quote me on that. But we let them know that based on Florida Statute 39.01, in no case shall an employee or agent of a Department of Social Service agency acting in good faith be liable for damages. Once again, unless the failure to provide such services occurs as a result of bad faith or a wanton and willful disregard of human rights. Ignorance of the law is no excuse to violate somebody's rights. Okay? We also went along and made sure that they were aware of what the definition of institutional child abuse and neglect is. And child abuse and neglect means not allowing them to have a medicine that's medically necessary. If a social worker tries to interfere with a doctor's order, the social worker is acting as a physician. They will be stripped of their immunity, and they will be charged personally without immunity, and we will attempt to make sure that they're charged criminally as well. Okay? And the one thing I wanted to show on here is necessary medical treatment. Necessary medical treatment means care which is necessary within a reasonable degree of medical certainty to prevent the deterioration of a child's condition or to alleviate the pain of a child. Does it say it has to be a prescription? Not at all. It says within a reasonable degree of medical certainty. If a physician states that this is medically necessary for a child, they are acting, Department of Children and Families, should I say, are acting in wanton and willful disregard of the human rights of a child. Human rights are given to you at birth. And actually in some states at 24 weeks of conception, from what I believe. We have a OBGYN here in the crowd, so we got to make sure they're aware of that. And then, of course, we define the Florida statute of 44 of 39.01, which we define when neglect occurs. And it occurs when a child is deprived or is allowed to be deprived of necessary food, clothing, shelter, or medical treatment. We already saw the definition of medical treatment. We have advised the Department of Children and Families, if they touch a single hair on a child's head in the state of Florida, we will make sure that they will be stripped of their immunity and they will be prosecuted to the fullest extent of the law for institutional child abuse. That is why Renee Petro's case was closed by the Department of Children and Families. That is why children are allowed to use this now in the state of Florida, of course, on a case-by-case basis. We're not giving you legal advice on that. We're saying contact DCF. I do want to get into quickly just a few client cases that we have here, just for people to kind of put a visual with this as well. We have a patient, her name is Kelly. She's in Volusia County. The Volusia County Sheriff is aware that she was using this medicine. She was diagnosed at 38 years old with triple-negative advanced metastatic breast cancer. She went through a double mastectomy and 2 rounds of chemotherapy. They failed. In November, they diagnosed her with stage 4. They gave her a prognosis of 2 to 3 months to live. She had nowhere to turn. She heard something about Health Law Services, that there was some kind of option here. She contacted us. In November, she began using cannabis oil after exhausting all options. We have her scans here. I apologize if they're a little blurry, so you may not be able to see them here. But the first scan shows a full homogeneous uptake of cancerous activity. And that is November 1st. That's when they stopped her chemotherapy and put her on morphine for palliative care. March 14th, if you see at the bottom here, the PET scan is negative. They did not find a single cancer cell in her body by taking 1 gram of cannabis oil per day. She is cancer-free in Florida. The second case that I want to bring up here is Christina. Now, for those of you that aren't aware, there is a group here, actually you're aware now, of CannaMoms. We support them wholeheartedly. We're here for them till the end. Thank you. A couple of the parents that we're going to talk about, or a couple of the children, the parents are here. Christina is the daughter of Annalise, who is up here. She was diagnosed at 2.5 years old with intractable epilepsy. At 8 years old, after undergoing all of the traditional treatment, she underwent a radical hemispherectomy and had part of her brain removed because they said that this would help her. 2 days post-op, she began seizuring uncontrollably once again. Now, Annalise has received recommendations from physicians, and Christina was given CBD-rich cannabis beginning in January. As of today, she's 9 years old, she's seizure-free, but she does still require constant care because she had brain surgery. Not because of the seizure activity, because she had brain surgery. This needs to stop in this state. We all need to make sure that our law enforcement, our elected officials, and more importantly, our parents know their rights are not to be violated in the state of Florida. That is why we go to the end of the earth for these parents. One last case here, and this is somebody that I have spoken to really from the beginning of us starting this, is Dahlia. Dahlia was diagnosed with astrocytoma. It is brain cancer of the hypothalamic region and the prefrontal cortex at 2 years old. She was actually on the news with John Morgan, and they were talking about the fact that she needed this medicine here currently. Dahlia underwent 2 rounds of chemotherapy, which was largely unsuccessful, and her mother, Mariah, who's sitting here as well, was told there was nothing more that can be done. She went to St. Jude's in Tennessee. During that time, she was in contact with us constantly, and although she was aware that she had a medical necessity to do this here in Florida, her fear was the Department of Children and Families, okay? So Mariah did what any good parent would do. She said, I'm gonna take my child wherever I have to go to get this. And so she went to Colorado to see some physicians out there. Interestingly enough, while Dahlia was in Tennessee at St. Jude's, on December 16th, Alan Shackelford, who's responsible for creating this CBD-rich strain of cannabis, who treated Charlotte Figge, was in Florida doing a seminar on our behalf, and this is a gentleman that I worked with extensively in Colorado as well. He was at the fundraiser for Dahlia. It is a sad day when an expert physician comes to Florida who can treat a child here, but has to raise funds for the child to leave the state and be a refugee in Colorado. It is untenable. We can't take this, okay? I don't think we could read these here, but these are the certifications for Dahlia. And if you see, I know it's a little difficult in the back, but at the bottom left of here, it states that she is required to have 600 milligrams of THC and CBD per day. That is because THC is required for brain cancer. Absolutely necessary, which is why we also need whole plant extracts here in Florida, okay? As of today, or should I say as of April 6th, which is when we got the documentation from you, Mariah, Dahlia's primary tumor has shrunk 38.2%, and her secondary tumor in her prefrontal cortex is completely gone as of today. And now, this was done in Colorado, but as you can see, Mariah and Dahlia and all the other moms that are finally coming out of the closet here because they're no longer fearing the state are allowing all of these other parents to understand this as well. So to you guys as parents, we thank you from the bottom of our hearts. Thank you. I did want to say one more thing here. I do apologize. Here's the requirements needed for someone to establish a medical necessity in the state of Florida. Now, we have spent the last year working with law enforcement to ensure that if somebody meets these requirements and they have the proper documentation, they're not going to be messed with in the state of Florida. Can't say that for sure about Polk County. They haven't quite signed on to that one yet. But if they do, they have been made well aware that we will prosecute. We will do everything we can to strip them of their immunity, okay? We're waiting for it to happen at this point. But what is required is somebody has to have medical records with a diagnosis supplied by a licensed physician. This is based on state requirements. It also requires a statement of medical necessity from a licensed physician. As a reminder, physicians have a First Amendment right to state anything they like. They just cannot tell somebody where to go and get the medicine. It requires a legal memorandum, and this actually was based on Kathy and Robert Jordan, and because the medical records were supplied through counsel, that is what the state is requiring currently. So it requires a memorandum of understanding of applicable state law from an attorney and the warning to law enforcement. We put the warning in there just to make sure. It also requires proper power of attorney documentation for a caregiver for patients who are unable to cultivate medicine themselves due to their debilitating condition. So yes, you can be a legal patient in Florida today. Yes, a caregiver can cultivate medicine. Similar to the laws in California, you cannot sell this medicine. We want United for Care. We want the Amendment 2 to pass. We want to make sure that people have proper access to be able to walk into a facility and have tested medicine. But for those currently suffering, you do not have to wait another year and a half to have access to this medicine. Contact somebody who can grow it for you. Contact an attorney. I'm sure any one of these attorneys up here would be happy to help you. There's numerous others in the state of Florida. But you remember, if there's anything to take home with you, it is that you do not have to go to jail to use cannabis. It is a medicine. It is not a drug. I'll leave it at that. Thank you.